entered into before the Act. The law should be applied to all instruments whenever entered. So, again, changes there. So we're hoping, after our discussion, that the government's amenable to those changes, and certainly they have indicated that they will be. I want to read the stories of some of the amazing women who are involved in making this day happen. So first of all, Kirsty's story, who's here with us. When Kirsty Mathers McHenry's wife was in labour, the unthinkable happened. And her wife is here too. There were complications, and doctors warned Kirsty that there is a chance that her wife could die. At that moment, holding her newborn baby, she watched doctors frantically try to save her wife's life. This is from a press clipping. It also dawned on her that she may be raising the child as a single mum. If that nightmare was not horrifying enough, Kirsty also realized she would not be a legal parent to her own child. Quote, "As I held my wife's hand and snuck glances at the 2 rolls of paper unspooling and recording the 2 heartbeats, I went through the possibilities. If my wife died, I might not be able to leave the hospital with our baby. Who would be able to? My in-laws? They were supportive. Maybe the hospital would let the baby leave with them. Our sperm donor, he was known to us, was another possibility. Maybe he could pretend to be more than a donor uncle for a morning and get us home." Unquote. In the end, Kirsty's wife and new baby were both fine, but the experience was traumatic and highlighted a major gap in the current system. Again, quote, "My wife was okay and our daughter was okay, and we left the hospital together after visits from family. Months later, we obtained a court date, and the 3 of us, with our lawyer, went to court to make me a legal mummy," unquote, she said. The story has a happy ending, but the flaw in the system must be fixed. Parents should not be forced to adopt their own children. So it's a pretty dramatic example. Thank you. Kirsty and Jennifer, thank you. Applause should be given to them for being here. So again, this has dramatic effect, and should have dramatic effect if it's done correctly. Here's another story. Again, these are taken from press clippings. Raquel's story. Raquel Grand and Deanna Dios are the mothers of 2 children, Thora and Alo. Deanna is the genetic mother of Thora, who was conceived with the sperm of a known donor. Raquel is the genetic mother of Lo, who was conceived with the sperm of the same known donor. Both births were difficult, with serious medical complications. Raquel writes, quote, "A short while after Thora entered the world, it became obvious that Deanna was hemorrhaging badly and her body was not responding to the care the midwives were giving her. The midwives transferred Deanna's care to the surgical team at St. Michael's Hospital. I stood at the side of the room and held onto our new daughter and watched in horror as my wife passed in and out of consciousness, trying not to notice the alarming amount of blood that was accumulating on the floor around her bed in the form of soaked rags, and the panicked scramble of midwives, nurses and doctors as they tried to gain control of this unpredictable medical situation. I stood on the side of that room for 6 hours, holding the sturdy little body of our newborn baby who was full of life, as I hoped that my wife would not lose hers. More than once I realized that I might have to raise this little girl on my own. More than once it dawned on me that I was not even Thor's legal parent, as I had yet to adopt her. Would I be able to adopt my own child if my wife died? Would I lose custody of her because I was not her biological mother? These were questions I had to consider while holding out hope that Deanna would not leave us. We still had to contend with the matter that Thora needed to be adopted by me, and Mike had to sign his parental rights over. Despite making it through a very difficult birth, Deanna was still not well. She had lost a lot of blood and was very weak. Her iron levels were dangerously low. It was recommended she remain on bed rest and not go anywhere that was unnecessary. However, due to the scare we had, we realized that Thora could lose both of her mothers if anything happened to Deanna. We felt it was very necessary to set up appointments with lawyers and get Thora's adoption process sorted out, even though Deanna should not have been out of bed. We spent more than a few days attending meetings and seeing lawyers for Deanna, Mike, and myself. We spent thousands of dollars that should have gone into an education fund for Thora. In the end, the three of us got what we wanted. I became Thora's other legal parent, and Mike was able to sign over his parental rights. Slowly, Deanna regained her health, and finally, we were legally a family of three, unquote. Again, severe psychological stress in the midst of severe physical stress, and again, because the law failed to recognize their parentage. Finally, Donna's story. And I'm reading these stories because we're not talking about something in the abstract. We're talking about real people, real mothers, fathers too, real babies, and what the current status quo means if we don't act, if we don't pass this bill with amendments. There really, Mr. Speaker, there is no excuse for doing nothing. And by the way, again, working with the government, we're hoping that babies born in the interim before this bill becomes law will also in some way be covered, because there are babies being born, and I've heard from their parents. And here's Donna's story from a Globe and Mail piece. Donna McDonough's daughter was born in the autumn of 2006, an exciting time in the province of Ontario for lesbian couples. A law was about to change, allowing two mums to put their names directly onto a child's birth certificate. Their baby was the first in Ottawa to have a birth certificate listing two women as parents. Both McDonough and her partner Kay were in their 40s when they decided to start a family, but Kay had embryos that she created some years earlier using her own eggs and donor sperm. McDonough was there when the embryo was transferred into her partner's uterus, there for the doctor's appointments, the prenatal classes, and there for the birth. Because Kay was self-employed and McDonough was a federal government employee, McDonough took parental leave and was the primary caregiver for most of the first 11 months of their baby's life. McDonough had every reason to be confident that she was a full parent before the law. Not only was her name on the birth certificate and their child's last name a hyphenated hybrid of the two mums' surnames, but the two women had signed an order of joint custody, declaring that their intention was to co-parent with an equal say in the child's life. She was granted paid and topped-up parental leave. She had successfully applied for the baby's health card and social insurance number and was named as parent on the application for a passport. Wills, powers of attorney, everything signal the same intent, that she and Kay would play equal roles as parents. Quote, "I really felt that we were good," quote, McDonough recalls. McDonough was aware that birth certificates were just the beginning, that there were other laws that were still awaiting revision, but she was confident that it would just be a matter of time before everything was updated, as Justice Paul Rivard had said it should be in the 2006 landmark case that made the birth certificate changes they had taken advantage of. She says, "I trusted in the process." But in August 2009, the relationship ended. At the time of the breakup, Kay agreed that there would be joint custody, but there was a loophole in one of the laws governing parentage, which could be used to cut McDonough out. The law was the Children's Law Reform Act of 1990, and the loophole was that a non-birth, non-biological parent could only be presumed to be a parent if the person both cohabited with the birth mother and was male. McDonough isn't male. This detail was one of the several bits of law that Justice Rivard had indicated was in need of updating, saying that lesbian mothers were correct to argue that they shouldn't have to ask permission to be parents of their own children. But those updates never happened. McDonough's name on the birth certificate, it turned out, meant very little. The two women fought it out through the courts. In the end, after more than 2 years and hundreds of thousands of dollars in legal costs, McDonough was finally granted joint custody of her daughter. This again, to the member from Lanark, Frontenac, Lennox and Addington's point, if you really want to clear up the courts and the fights in courts, this equal parenting bill is absolutely critical. So again, I've gone over some of the problems. Some amendments are absolutely needed. There is no question, and we've heard about those amendments from the stakeholders. right across the spectrum, and I'm sure we will hear about them when the bill goes to committee, and that's something I wanted to talk about too. Because there is a process in this place. Not only has this bill been waiting 10 years to get here, not only have the courts ruled 10 years ago that it should happen, not only was the government given a deadline of September 30th to make it happen, hence this bill, and now here we are with all of the court documents, with all of the research that's gone into it, but we still have time, Mr. Speaker. So to those who have concerns about amendments, the amendments that I've already pointed out, and about, quite frankly, anything else, there is a chance at committee to testify. That's what committee is for. So by all means, put your name on the list and testify at committee, and then there's time for clause by clause, and that's where the amendments come in. That is part of the process here, and we will be putting forward amendments. The New Democratic Party have already listed what those amendments will be. I understand the government is in a court. Hopefully they'll put forward their own as well. And the Progressive Conservative Party are welcome to put forward amendments at that time as well. But to argue that there hasn't been enough time spent on this bill is a bit rich. We're talking about over a decade, and we're talking about hundreds of thousands of dollars of legal bills and court time being taken up fighting for what we've got in front of us, hopefully with amendments. Hundreds of thousands of dollars of legal bills and court hours taken up. To argue that this is going to create more court hours is a bit rich. And finally, we're talking about the health and well-being of children who are being born almost as we speak, because we need our children to be safe, all of our children. Children with families that look different from ours. We need them to be safe too. And they cannot be safe if their parents are not equal. It's that simple. They cannot be safe if their parents are not equal. And to go over the case again that I made, the non-biological parent, without the thousands of dollars of legal costs and going through the courts and officially adopting their own child, would not have the right to take that child to a doctor if that child was in urgent need of medical care. That's not safe, and that's not in the best interests of the child. And I would argue not being equal is not in the best interests of the child. And I would argue even further to that, because I've given you a kind of spectrum of 45 years of action on the LGBTQ2S file, that when that child goes to school, if they're not met with equality in the classroom in terms of how their families are viewed, and this is all part and parcel of what we're talking about, because if they're not equal before the law, then are they equal anywhere else? Arguable. Arguable. If they're not equal at the time of birth, then are they really equal when they go to school, when they move through life? And we're talking about children here. So again, we've all been and come a long way, I think. I read today with some, I was very moved by it. A friend of mine, Michael Corrin, wrote an article, I think it was in the Star, in response to the uproar of the sex ed curriculum, and said exactly what I've been saying forever, and others, that really the objection to it is homophobic and transphobic in essence, and pointed out the signs. And this was the Michael Corrin that I spent months and months debating back in the day around the issue of same-sex marriage, because it would be me wearing my collar and him on other sides of this issue. We made the media gamut, and he was adamant, and he had his television show, and I would be on it, and he's a constituent of mine. We would agree on many things, we disagreed on that. And to see how far he's come, to the point that he's written a book about his conversion, because it is a conversion, and that he's writing articles like the one that I read just this morning, is to really see how far many have come in Ontario and many have come in Canada. And I get that not everybody has had the life experience I've had. I get that not all families have had our family's experience, but I think when we talk about equality and we talk about parental equality, I think when we reach out and show people that really the face of this bill, it's not the face so much of a parent, it's the face of a child that is playing, just like all of our children play, no matter what their family background, in the schoolyard. And can you really tell by looking at that child what they say, how they play, their antics, what kind of family they've come from? Whether they've got two mums, two dads, two mums and two dads, trans parents, straight parents, queer parents. Who cares? At the end of the day, who cares? We shouldn't care what their family looks like. When we talk about trying to diminish the effect of bullying in our schools, how can we say that and then come here and be bullies ourselves in not supporting parent and child equality? How could we come here and say some families are more equal than others? Some parents and some children have more rights than others. How can we not model what we ask our teachers and the children in our schools to model, which is to accept and love each other the way we are? That's very simple, really. It's very simple. And there is nothing that is not in the best interest of the child in that. To argue anything else is to argue against the best interests of the child. So I've read personal stories from some amazing and remarkable activists. And I have to say that the women sitting here in our galleries, and many, many more out there, and many more really looking back over the decades that have brought us to this moment, because we are unique in this province. And I think we have a lot to be thankful for, that we actually live in a province that's come this far. One would argue this fast. I wouldn't, because it's 45 years later. But come this far on this file. But we're not there yet. And this will put us a step closer. Something else that's coming up. On November 20th, we're going to be recognizing and having, 21st, I think is a Monday when the House sits, having a moment of silence around Trans Remembrance Day. And we're going to be raising the flag out front, the trans flag on Trans Remembrance Day, the first time that's ever happened at Queen's Park. Last year, I think, was the first time the Pride flag went up. I remember when Dyke Day started, and I remember actually performing the first legalized same-sex marriage. After Brent showed us you could marry by bands, not legally, but you could do it in a church, I thought, great, I'll do that. Married two women, sent it in. Registrar General's office, this is back before the law changed, thought Paula and Blanca were two men's names. There's nothing about male and female on the form, and vetted it, and it became de facto the first legalized same-sex marriage in North America, actually. And we celebrated that by always marching in the Dyke Day. They in their wedding dresses, me driving the convertible. It was fun. It's a long history. It's a long history that's brought us here. Long history. And it's been a hard-won history. We've lost a lot of people in that history. And by lost, I mean actually lost, without going into the AIDS crisis, but there was one and there still is, and we're still not dealing with that in any kind of equality. We still have discriminatory blood laws in this country. We still force gay men to go on ODSP just to cover their medication. That's unconscionable in this province. We still do that. We still have work to do on that file. We still have work to do on the trans file, where 50% live in poverty and 50% have attempted suicide. We still have work to do on that file. But today, we have a chance to do something to move us ahead. And that is, let's pass this bill, let's get it to committee, let's get it looked at in committee, let's give everybody a chance to say their piece, let's go through it clause by clause, and we will, so amendments can be made to make it stronger, because it needs to be stronger, needs to be changed in some pretty important ways. And then we will be able to say to Bree and those of her generation, their generation, we will be able to say, when it's time for you to have children, whatever your family looks like, you won't even remember a time when you had to go through a whole separate process just to make sure your child was recognized in law. And, you know, they'll say to us, really? You really had to do that back then? Really? You really had to do that? Really, there was something preventing you from doing that? Really, it was only a man and a woman? We will seem like such dinosaurs. So let's get out of the Jurassic age and into the present. Let's pass this, at least for second reading. Let's put it in committee. Let's recognize all of those who've gone before, all of those incredible activists, many of whom are here and many of whom we should pay tribute to for all their outrageously difficult work to get us here. We're not quite there yet, but with any luck at all, by Christmas we will be, and that will be the best gift of all. Thank you, Mr. Speaker.